Emergency Planning and Community Right to Know Act. The Emergency Planning and Community Right to Know Act of 1986 is a United States federal law passed by the 99th United States Congress located at Title 42, Chapter 116 of the U.S. Code, concerned with emergency response preparedness. On October 17, 1986, President Ronald Reagan signed into law the Superfund Amendments and Reauthorization Act of 1986, SARA. This act amended the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, CERCLA, commonly known as Superfund. A freestanding law, the Emergency Planning and Community Right to Know Act of 1986, EPCRA, was commonly known as SARA Title III. Its purpose is to encourage and support emergency planning efforts at the state and local levels, and to provide the public and local governments with information concerning potential chemical hazards present in their communities. Background: during the early morning hours of December 3, 1984, a Union Carbide plant in a village just south of Bhopal, India, released approximately 40 tons of methyl isocyanate mic into the air. Used in the manufacture of pesticides, mic is a lethal chemical. The gas quickly and silently diffused over the ground and in the end killed, by some estimates, upwards to 5,000 people and injured 50,000 more. The only other place in the world that Union Carbide manufactured mic is at its Institute plant in the Kanawha Valley of West Virginia. A week after the Bhopal accident, on December 11, 1984, Hank Carowan, then plant manager of the Union Carbide's Institute facility, held a press conference at which he expressed his confidence in the safety of the Institute plant's operations. All of us here at the Institute plant have been deeply saddened by the tragic event in India, and we extend our sympathy to all the people in the city of Bhopal. I am pleased to have the opportunity to make a point here this morning. Employees of the Institute plant have been manufacturing mic in an effective and safe manner for 17 years. We are extremely proud of that safety record. We are confident in the ability of our trained, dedicated, skilled, and experienced people. We are confident in the equipment that we operate, the safety precautions that we utilize, the monitoring systems that we have, and our plant emergency preparedness. Despite Mr. Carowan's vote of confidence for the safety of the mic operations at his plant, Union Carbide elected to shut down production of the deadly chemical until it could make $500 million worth of safety improvements. On May 4, 1985, Union Carbide resumed production of mic. On August 11, 1985, on the heels of the completion of the safety improvement program just a few months before, 500 gallons of aldocarboxime and highly toxic mic leaked from the Institute plant. Although no one was killed, 134 people living around the plant were treated at local hospitals. Both the Bhopal and the Institute incidents underscored the reality of modern-day chemical production. No matter what safety precautions are taken, no matter how well-trained a plant's employees may be, and no matter how prepared a plant may be to handle an emergency situation, accidents may still occur. Indeed, around the time of the Bhopal disaster, 6,928 chemical accidents occurred in the United States within a 5-year period. In response to this growing threat, the United States Congress passed the Emergency Planning and Community Right to Know Act, EPCRA, in 1986. Primary responsibilities: EPCRA reporting requirements. EPCRA does not place limits on which chemicals can be stored, used, released, disposed, or transferred at a facility. It only requires a facility to document, notify, and report information. Each section of the law, however, applies different requirements, has different deadlines, and covers a different group of chemicals. Emergency Planning Sections 301, 303, 42 U.S.C. SSSS 11001-11003. These sections are to ensure that state and local communities are prepared to respond to potential chemical accidents. As a first step, each state had to establish a State Emergency Response Commission (CERC). In turn, the CERC designated local emergency planning districts. For each district, the CERC appoints, supervises, and coordinates the activities of a local emergency planning committee (LEP). The LEP must, in turn, develop an emergency response plan for its district and review it annually. The membership of the LEP includes representatives of public and private organizations as well as a representative from every facility subject to EPCRA emergency planning requirements. The plan developed by the LEP must identify affected facilities and transportation routes, describe emergency notification and response procedures, designate community and facility emergency coordinators, describe methods to determine the occurrence and extent of a release, identify available response equipment and personnel, outline evacuation plans, describe training and practice programs and schedules, and contain methods and schedules for exercising the plan. Determining if a facility is subject to the EPCRA emergency planning requirements, the Environmental Protection Agency (EPA) has published a list of extremely hazardous substances (EHS). For each EHS, the list includes the name, the chemical abstract service number of the substance, and a number called a threshold planning quantity (TPQ). The TPQ expressed in pounds is the critical number. If a facility has within its boundaries an amount of an extremely hazardous substance equal to or in excess of its threshold planning quantity, the facility is subject to the EPCRA emergency planning requirements and must notify both the CERC and the LEP of this fact. The facility must also appoint an emergency response coordinator who will work with the LEP on developing and implementing the local emergency plan at the facility. Emergency Release Notification Section 304-42 U.S.C. SS 11004. A facility may be subject to these reporting requirements, even if it is not subject to the provisions of Sections 301-303. This section applies to any facility which stores, produces, or uses a hazardous chemical, any chemical, which is a physical hazard or a health hazard and releases a reportable quantity RQ of a substance contained in either of the following two tables published by the EPA in the List of Extremely Hazardous Substances and List of CERCLA Hazardous Substances. The RQ is the critical number that determines if a release must be reported. This is a number expressed in pounds that is assigned to each chemical in the above-mentioned tables. If the amount of a chemical released to the environment exceeds the reportable quantity, the facility must immediately report the release to the appropriate LEP and CERC and provide a written follow-up as soon as practicable. Immediate notification must include the following: the name of the chemical, the location of the release, whether the chemical is on the extremely hazardous list, how much of the substance has been released, the time and duration of the incident, whether the chemical was released into the air, water, or soil, or some combination of the three, known or anticipated health risks and necessary medical attention, proper precautions, such as evacuation, and a contact person at the facility. In addition to immediate notification, facilities are required to provide a follow-up report in writing, updating the original notification, providing additional information on response actions taken, known or anticipated health risks, and, if appropriate, advice regarding any medical care needed by exposure victims. Failure to notify the proper authorities may result in civil penalties of up to $25,000 per day for each day of noncompliance and criminal penalties of up to $25,000 in fines and prison sen. Of course, there are exceptions. A release which results in exposure to persons solely within the facility boundary or is a federally permitted release does not have to be reported. Also, continuous pesticide and radionuclide releases meeting specified conditions are exempt. Community Right to Know Reporting Requirements Sections 311-312-42 U.S.C. SSSS 11021-11022 The purpose of these requirements is to increase community awareness of chemical hazards and to facilitate emergency planning. This section applies to any facility that is required by the Occupational Safety and Health Administration (OSHA) under its Hazard Communication Standard to prepare or have available a safety data sheet SDS for a hazardous chem. For any one day in a calendar year, an amount of a hazardous chemical equal to or greater than the following threshold limits established by the EPA: 10,000 pounds 4,500 kg for hazardous chemicals or coals or lesser of 500 pounds 230 kg or the threshold planning quantity TPQ for extremely hazardous substances. If a facility is subject to reporting under these sections, it must submit information to the CERCLA, the LEP, and the local fire department with jurisdiction over the facility under two categories: SDS reporting and inventory reporting. SDS reporting. SDS reporting requirements specifically provide information to the local community about mixtures and chemicals present at a facility and their associated hazards. For all substances whose on-site quantities exceed the above threshold limits, the facility must submit the following: initially, a copy of the SDS for each above threshold chemical on site, or a list of the chemicals grouped into categories, and within 3 months of any change, an SDS or list for additional chemicals which meet the reporting criteria. Inventory reporting. Inventory reporting is designed to provide information on the amounts, location, and storage conditions of hazardous chemicals and mixtures containing hazardous chemicals present at facilities. The inventory report has two forms. The Tier 1 form, the simpler of the two, contains aggregate information for applicable hazard categories and must be submitted yearly by March 1. The Tier 1 form is no longer accepted by any state. The Tier 2 form contains more detailed information, including the specific names of each chemical. This form is submitted upon request of any of the agencies authorized to receive the Tier 1 form. It can also be submitted yearly in lieu of the Tier 1 form. Toxic Chemical Release Inventory Reporting Section 31342 U.S.C. SS 11023. Under this section, the EPA is required to establish the Toxics Release Inventory (TRI), an inventory of routine toxic chemical emissions from certain facilities. This inventory is intended to inform the public about releases of toxic chemicals. The data gathered is also intended to assist in research and development of regulations, guidelines, and standards. The original data requirements for the TRIs, specified in SARA Title III, have been greatly expanded by the Pollution Prevention Act of 1990. The TRI must now also include information on source reduction, recycling, and treatment. To obtain this data, EPCRA requires each affected facility to submit a Toxic Chemical Release Inventory Form R to the EPA and designated state officials each year on July 1. A facility must file a Form R if it has 10 or more full-time employees, is in a specified standard industrial classification code, and manufactures more than 25,000 lb/year of a listed toxic chemical or processes more than 25,000 lb/year of a listed toxic chemical or otherwise uses more than 10,000 lb/year of a listed toxic chemical or manufactures, processes, or otherwise uses a listed persistent bioaccumulative toxic PBT chemical above the respective PBT reporting threshold. PBT reporting thresholds can vary anywhere from 0.1 grams for dioxin compounds to 100 pounds 45 kg for lead. On October 29, 1999, EPA published a final Rule 64 FR 58666 adding certain chemicals and chemical categories to the EPCRA Section 313 list of toxic chemicals and lowering the reporting threshold for persistent bioaccumulative toxic PEB. On January 17, 2001, EPA published a final Rule 66 FR 4500 that classified lead and lead compounds as PBT chemicals and lowered their reporting thresholds. In December 2006, the EPA finalized a new TRI rule which expands eligibility for use of the Form A certification statement in lieu of the more detailed Form R. Details about this final rule can be found on the EPA website under TRI reporting. Federal agency responsibilities under EPCRA. Since April 30, 1993, the United States Air Force, in accordance with AFR 355-1, Disaster Preparedness, Planning and Operations, has voluntarily complied with Sections 303 and 304 of EPCRA in spite of the fact that federal facilities were initially exempt from its requirements. On August 3, 1993, President Clinton signed Executive Order 12,856, Federal Compliance with Right to Know Laws and Pollution Prevention Requirements. This executive order requires federal agencies, including the Department of Defense, to fully comply with all provisions of EPCRA and the Pollution Prevention Act, with one notable exception, the reporting requirements under Section 313. Currently, a non-federal facility must file a Form R only if it is in a specified standard industrial classification SIC code. This exclusion does not apply to federal agencies. Federal agencies will comply with the provisions of Section 313 regardless of the SIC code that applies to their facilities. Lists of chemicals. Sections 302 and 311, 313, 42 U.S.C. SSSS 11002 and 11021-11023. The EPA Guide provides a useful description of the four groups of chemicals subject to reporting under the Emergency Planning and Community Right to Know Act. Extremely hazardous substances. This list currently contains more than 300 chemicals. Because of their extremely toxic properties, these chemicals were chosen to provide an initial focus for chemical emergency planning. If these chemicals are released in certain amounts, they may be of immediate concern to the community. Releases must be reported immediately. Hazardous substances. These are hazardous substances listed under previous Superfund hazardous waste cleanup regulations, Section 103 of the Comprehensive Environmental Resource and Conservation Liability Act Superfund. The current list contains about 720 substances. Releases of these chemicals above certain amounts must be reported immediately because they may represent hazardous chemicals. These chemicals are not on a list at all, but are defined by Occupational Safety and Health Administration regulations as chemicals which represent a physical or health hazard. Under this definition, many thousands of chemicals can be subject to reporting requirements if a facility manufactures, processes, or stores them in certain amounts. Inventories of these chemicals and material safety data sheets for each of them must be submitted if they are present in the facility in certain amounts. Toxic chemicals. There are now more than 320 chemicals or chemical categories on this list, which were selected by Congress primarily because of their chronic or long-term toxicity. Estimates of releases of these chemicals into all media, air, land, and water must be reported annually and entered into a national database.